welcome back to the Men's Divorce Virtual Town Hall in Cordell Cordell. I'm Scott Trout, Managing Partner and CEO of Cordell Cordell. And so this is our second installment in a different format of our virtual town halls we hold each month, where we know you have questions and we're hopefully here to give you answers. And that's what we're going to do today, with no general or organized format other than to simply answer your questions. So you want to do that right now in the Q&A section. If you have questions, go ahead and submit those. Give us your first name and where you're located. And that way we can try to at least give you a general idea, especially if one of our attorneys of Cordell Cordell are in your state. We can try to be a little bit more precise in our direction. Now, keep in mind, as always, it's general information. We can't provide legal advice because we don't know the specifics, the details of each of your situations. And that's really what's required to give you proper legal guidance and advice. So this is really informational. And we expect you to be able to take this to your attorney and to ask questions and get more details. Speaking of that, if you want to have a consultation with an attorney and meeting with an attorney, that's really the best place to do it. You can go to our website, CordellCordell.com, and you can schedule your consult right there. You don't even have to pick up the phone. Up there, you'll pick your city, your location. You can go ahead and schedule. You'll find a calendar and all the times you can meet either virtually, just like this. You can go into the office, meet in person, or you can do it via phone. CordellCordell.com, or you can give us a call, 866-DADS-LAW. So today we're joined by two of the Cordell and Cordell attorneys. Presley, we're in Florida. Welcome.
Hi, Scott. Good afternoon. I'm Presley Davis. I am located in Jacksonville, Florida, and I've been with the firm 2 years coming up next month. So thank you for having me today.
Great. Thanks. And then rounding out for today to answer your questions is Christopher Kennedy down in Arizona. Welcome.
Good morning, Scott. It's still morning here in Arizona. Christopher Kennedy here. I'm a lead litigator with the firm. Just finished up almost 6 years here now with Cordell and Cordell, and happy to be here today. Thank you.
Great. Well, thanks. So we're going to get to your questions. Don't forget, put them in the Q&A section. We'll start talking a little bit about some of the updates in the court system as we let your questions roll in, but use that Q&A section. You can do that now. And we're going to come right back after this very brief message.
Family moments matter, even when they don't go as you planned. Cordell and Cordell is a champion for fathers' rights. Kids count on fathers. Fathers can count on us.
All right, welcome back. I don't know if you may join our virtual town hall each month that we do this, but if you haven't subscribed to our podcast, you should do that. We drop a new podcast where we spend between 10 to 30 minutes just talking about topics in family law. And I did one yesterday, which I thought we could start off while we wait for questions that come in the door. And that is mediation. Each client, and I thought it was a great topic to discuss yesterday, because mediation sometimes has a very different connotation, understanding by clients. I just want to toss it out as questions are coming in. Presley, does Florida have a required mediation for clients that are proceeding in family law?
Yes, Florida does. Every case in Florida is required to attend mediation prior to setting the case for trial. Sometimes they even require it before you go to a temporary relief hearing where you're asking for alimony and child support. So mediation is absolutely required and encouraged.
Mm-hmm. What about in Arizona, Christopher?
Likewise, Scott, I wouldn't say that it's actually mandatory. However, the practice of most judges here is to require the parties to attend mediation prior to setting a trial for date. A date for trial.
Yeah.
In modification hearings, a lot of times it is actually required before you can even file a petition with the court here in Arizona.
And I want to talk more about mediation just because there are, as I preface, different understandings of what it is, formal, informal, why should I do it, how do I do it, as we'll talk a little bit more about it, but we do have our first question. I'm going to go ahead, Christopher. Oscar in California, obviously we don't have a California licensed attorney on, but we're going to talk generally. Oscar's paying child support. There's a standard monthly amount and a percentage for overtime and or bonuses. If Oscar receives a bonus in the form of stock, can Oscar forward the amount due for child support in stock since I received it in stock? And I'll throw my 10 cents in once you're done, Christopher, and give me your thoughts.
Typically, Scott, no. Child support has to be paid most times directly through an income withholding or through a clearinghouse, if not directly to the recipient. Typically, that has to be in the form of currency, and it can't be stocks or
goods in kind, services rendered, right? Bartering. Right. I think typically the question really becomes in how, Oscar, your decree, your judgment is worded, and whether or not stock qualifies as a bonus. That is a benefit rather than perhaps a bonus. Stock options be given to you. So I'd want to look at your order, and typically I wouldn't even be wanting to send over the stock. Depends, it may be a much more valuable benefit that you're getting depending upon the performance of the company that you work for and perhaps the future. So I'm not quite certain I'd want to do that anyway. And it's a great example of how it's probably worth 30 minutes having a consultation, going through some of the options, looking at. Now, California may have a very specific provision that allows for in-kind payments. I doubt it. I've had that where clients have said, well, can I go over and mow the lawn in exchange for child support? Can I go and help fix the roof? Or, they're rehabbing the house. I get it. It's one of those things where you'd have to make sure it's in writing, it's done, it's by consent, and that even in and of itself can get you into some trouble. So I would not pay that in stock, and nor would I even consider it first and foremost as a bonus, depending upon how your judgment is worded, because it may be to your benefit, because it could be just supplemental income there that has not yet become ripe where you can't actually, cash the stock. So it may be an option to exercise stock that is not yet ready to be optioned and exercised. So all kinds of factors. Not only that, then there's tax consequences, because you ultimately can be paying the tax probably associated with the stock, even if you gift it. So you have to take a look at some of those factors. So I wouldn't do anything unless you meet with your accountant and or both, and your attorney as well. All right. So let me get back to mediation as we wait. And again, you can submit your questions in the Q&A section as we go along. So one of the things I talked about yesterday, and if you're all interested, you should subscribe to our podcast, because I think you'll find it very interesting. We talked about what it is, how it works, and why you should do it, and how you really should prepare. But when I talk about mediation, many clients look at it as this formalistic, as Presley, you mentioned, there's some requirements to go through where you have a neutral third party who sits there and works the issues between the parties and between perhaps the attorneys as well. And I like to engage. I'm curious your thoughts. And many times I'll tell clients, look, before we get going, we'll file the petition, we'll file the motion, whatever it is. But I'd like to call opposing counsel, get the opposing counsel and their client into a room with us and see if we can mediate it, kind of in an informal way. There is no neutral, but it is almost like a settlement negotiation, a settlement conference. I think it's a good use of time, depending upon where they are in their thought process. But and then I'll turn it over to Presley for a response. But one of the things I like about informal mediation is it gives you a peek into the case. It gives you a peek into what they want, and perhaps even better, a peek of what they have to be used against you. It's something I tend not to show. I liken it to poker. I don't show my cards in Texas Hold'em. That's why they keep them down, and you're covering your cards so no one else can see, so you can properly bet or bluff. So I'm curious what you do, and if you do any kind of informal mediation in Florida.
So what I do before all of my mediations is I try to get opposing counsel on the phone. I try to figure out what they're looking for, try to go ahead and exchange offers so that way we know where we stand going into mediation. If we don't get an offer, that's completely fine. Mediation is the place to get that information, regardless of if the case settles or not. I always tell my clients that it's an information expedition. If you don't know something, now is the time to find that out and try to see what type of cards they are playing with, because sometimes you don't find things out until you're at mediation. I was at one a few months ago, and we found out about a separate retirement account that wasn't disclosed previously. So after mediation, we did some additional discovery requests. So at a bare minimum, mediation, even if you don't settle, you're going to get some really good information. And I always tell my clients, even the ones that are like, I'm not going to go settle, I want to go to trial, at least give it a shot. Because when you're mediating, you have the opportunity to settle the case yourself. A judge isn't telling you what to do. It's you and the opposing party that are coming together through a third party neutral mediator to settle your own case. And what adult does not want to be responsible for their own decisions? I know personally, I would not want a judge deciding something for me when I have the opportunity to do it myself.
Right. I mean, a complete stranger who has complete control over your money, your property, and your kids. And it really is. And judges feel the same way, I think. They don't want to make those decisions for you. And that's why they do encourage you and sometimes push to try to get a resolution. And I tell clients all the time, look, I'm happy to not do it. If this is something that you feel is a waste of your time, let's not. I'm good. We are a litigation firm. I'm ready to go to trial. I like trial. I think sometimes trial is far easier than settling. It's less stressful. At least from my perspective, it's a lot of preparation, but it's less stressful. I've been trying to negotiate and mediate a case recently, and gosh, we've gone back and forth so many times, and we've wasted a lot of money, and we could have invested that in trial. So it isn't for everyone. All right, let me turn this over. We've got a question that has come in. Presley said, I thought I remember reading that cohabitation by my ex-wife can lower alimony, maintenance payments, spousal support, or get rid of it, as well as lower my child support payments because it takes into account the live-in partner of my ex-wife. How long do they need to cohabitate before I can make a claim for lowering of those two items?
So that's a very interesting question, Scott. I know that in Florida, there are a lot of different factors that you need to look at when determining whether or not you can modify alimony. You can modify or terminate upon death or remarriage of a party. Florida will certainly look into whether or not an opposing party's expenses are being paid by somebody and to what extent. But I can't really give much more of a detailed answer without knowing, what that state requires.
Yeah. And it really is. I take a look at your decree because when this is my 30th year of practice, I did used to routinely put in the decrees. Let's just peel out and separate child support from alimony for a moment, because it really matters more in my mind for the spousal support payments. So it would say death, remarriage, or cohabitation. Then there were some Court of Appeals decisions that came out that really clouded cohabitation, because what is it really? Is it living together? Is it dating seriously? Is it pseudo marriage? Is it living, as like what we would call a common law marriage that some states recognize, very few, by the way. But I do see it particularly as relevant. And, I know this question talked about Minnesota, but here in Missouri, it is relevant. We have, for example, I have a case where ex-wife is now cohabitating, living on a fairly routine basis with a boyfriend. And they're not getting married, and they're doing that intentionally. Why? Because the judgment specifically says alimony shall terminate upon remarriage. And they're working the system. So the modification is well-grounded when you have a boyfriend, a pseudo husband, pseudo spouse, or partner who is substantially contributing towards the expenses of the house. It's even better when they're living together, because now we know if both parties are working, they're contributing towards the marital home expenses or those expenses at the house. And that's what's going to come into play in my case is how much contribution is there? They go on vacations. Clearly, they're both probably contributing towards the mortgage, the utilities, the food consumption. So it does affect the need for alimony or spousal support. Georgia, I know, has an absolute bar to spousal support with regards to alimony when you can prove that type of behavior. And then the question is, my ex-wife's boyfriend moved in and she has the kids 50%. So let me tie in. I'm going to get Christopher's thoughts in a second. As it relates to child support, I think that's a far less strong argument, because judges tend to just look at it as formulaic and say, here's the amount, and it's based upon your custody and her custody, not necessarily additional income contribution. And I rarely see them include cohabitators' income when they calculate child support. So I think your argument is far stronger when it comes to spousal support than it is lowering your child support. That's my perspective. I think judges, it takes a lot to get them there. And it's much when it comes to kids, because they look at it as the money's the money. I don't care how much extra she or he may have by reason of cohabitating. Now, alimony, because it's statutory, for example, in Missouri, it's need-based. What are the reasonable needs and expenses to maintain a previous standard of living? Then we look at their ability to earn and what they're actually earning. So, and then can look at contribution from other sources. So win the lottery? Sure, that matters. Get an extra high-paying job? That matters. Get a third source of income that happens to come from a boyfriend? That matters. So I do think it's worth, of course, we have an office in Minnesota, in Edina. You can come on in and take a peek. We'll look at the judgment and tell you what it says and give you the idea of kind of what judge you may or may be in front of, what county. And one of our attorneys will have experience in that area. So, Christopher, what do you think?
Scott, I agree. As far as alimony goes, Arizona is also a needs-based calculation there, or determination from the courts. So, yeah, if you can show that additional source of income is there and demonstrate that party no longer has a need, you have a chance. I'm not saying a great chance here in Arizona, but a chance of having that modified. When it comes to child support, however, the guidelines here in Arizona are very clear that have what income can be included for purposes of child support and what cannot. And it's very clear, even when people remarry, that the new spouse's income is not used to determine child support here in Arizona.
Yeah. I just looked on dadsdivorce.com. If you haven't gone there, it's going to have plenty of information. It's one of our websites. Does mention and well pointed out that Minnesota, it looks like in 2019, talked about it now may be modified or even terminated upon the obligee's cohabitation. So, like Missouri does consider it, and Minnesota apparently does. So certainly it's well worth, and you should take action to modify because you can't go backwards until typically you can't see retroactive application unless you take action. So encourage the questioner to do that. And they followed up with one last one, which is, will child support then increase? So, and I'll try to answer a little bit is, in Missouri, we have a calculation and a chart of child support. In the chart, you include gross incomes of both parties, and then you also decrease the obligor's income by amount of maintenance payments, and you increase it by the recipient's payment. So clearly, it could affect the child support. And in fact, I can tell you what I typically counsel my clients on is two things. One, what are the likelihood of success on, for example, alimony? But I also look at it as let's look and be prepared for any counter motion to modify, because certainly that's going to come. I don't want that to come as a surprise. Are there opportunities? Is there something well-founded in fact and law where your ex-wife is going to go ahead and file for an increase in the child support, or perhaps an increase in the maintenance? It's kind of a holistic view to make sure you know what you're getting into when you choose to proceed on a modification. There are plenty of attorneys out there, they'll say, yeah, let's just go. It's cohabitation, not thinking more broadly about the impact of filing and what that effect will be. So it can generally affect child support because you're looking at the ability to pay and what it is. So let's see. Christopher, question from Stephen. Do I have to leave the home while the divorce process moves on?
That's a very hot topic. And the answer is it depends. I'm sorry to be so vague about that, but the short answer is no. Typically, you don't have to vacate the residence while your divorce is going on. You need to ask yourself, though, should I? In some cases, especially if it's very volatile between you and your potential ex, it might be better for you. It might be better for your children. It might be, just better all around to not live together in the middle of a divorce. It's one of the most stressful times of your life. Emotions are very high on both ends, and it could be a recipe for disaster. So no, you're not required to. If you can keep it amicable, by all means. I have plenty of cases that are able to do that, but for the majority of those, it's not a good idea in my opinion.
Yeah. I mean, it's I just met with someone with the very same question. Should I move out? In fact, they did. And I want them to move back in. Typically, if you've ever watched one of our seminars, it's loaded on our YouTube channel, and I'd go watch it. It's the 10 stupidest mistakes guys make when facing divorce. If you haven't watched it, go spend an hour and watch it. It's a great seminar where we really point out really the 10 most common things guys do, and before even thinking about it. And one of those is, should I move out? We talk a little bit about, can you be forced out? So in my case, where I just met with a client, we're going to take action to try to get her out. But there's kids. So Stephen, asks a follow-up question. No kids. She works. I'm retired, married 30 years. I just don't see, unless there's, I guess, facts or inferences of domestic violence, physical, psychological. My guess is judges don't want to remove the parties, at least here in Missouri. I'm licensed in Missouri, Illinois, and Georgia. And typically that doesn't happen a lot, absent some extenuating circumstances. And so, because what you're doing is you're taking, now for your case, Stephen, a single family income and trying to create two household expenses. And that's one of the reasons we don't move out, is you're creating double household expenses by doing so. The judge is going to be very aware and considerate of the fact that you're retired and she works. So I don't see that as a distinct possibility, nor would I encourage you to do so. But again, there's so many different facts and circumstances surrounding it. We want to make sure that we give you guidance. And that's when I even give the seminar, you're going to hear the same thing. My general answer is no, don't move out. No, you're not going to be moved out. But there's so many factors that go into that, that you need to really be consulting and considering that. So, nothing she could use against you to get you out is really and I just did another podcast on that a couple of days ago. Domestic violence, orders of protection, both against men and women. We talked really about men being victims of domestic violence. I do think it's probably the most abused code, section, statute, case law out there. And that is, you can go to court, make a wild allegation without proving it, by just saying it. I'm fearful for my life. He threatened me and I need him out, and you're out. So you got to be real careful. Don't engage. Don't get in arguments. Walk away. Go to another room. Go for a drive. Come back. But anyway, Stephen, I encourage you to have a consult. You'll feel a lot better. You'll be more informed and more educated on the process. All right, next question. Presley, my wife was awarded all 4 tax exemptions, even though I have the kids 50% of the time. This doubled my federal and state income taxes I pay and lowered my net at least by $1,500 per month. Can't lower my net income, and my ex-wife increased the net income. Can't that be taken into account in recalculating alimony and the child support? So Presley, and I'll kind of chime in as well. What are your thoughts on the tax exemptions when you're looking at child support?
So my thoughts on that are, was that something that you considered when you did enter? And I don't know if this was ordered by the judge or if this was a consent final judgment that you entered into, but that is something that should have been considered. We are not tax experts. We always encourage our clients to consult with someone who is a tax expert when these types of issues come up. But certainly, if there are a lot of other factors that come into your income, whether it's increase, decrease, your ex-spouse has had an increase or a decrease, then you can look into a potential modification. I know in Florida, the standard for modification is that it has to be a substantial, unanticipated change in circumstances since the entry of the last final judgment. So if there's other factors that are to be considered, then I know in Florida you could possibly seek a modification, but I also don't know which state this is coming from.
So the one thing, for example, in Missouri, the child support chart and the calculation itself assumes that, we'll call it the custodial spouse in Minnesota, this is where it is, would get the tax exemptions. Now that it's 50-50, so you're really going to have to look back at why it was given to your spouse at the time of the judgment to determine what's changed. Here's what could be changed, really. If your ex-wife is no longer or has insufficient income to use all 4 tax exemptions, it's a good justification. Why let it go to waste and let the government take more money from either you or her? Because there's a lot of instances where those 4 exemptions, the value is being wasted. The alternative that I've employed is saying, okay, going to your ex and saying, look, every year go to your accountant, figure out what using those 4 exemptions will cost you or give you a benefit. Let's just call it $1,000. So ex-wife gets $1,000 of tax benefit by using 4. You run your calculations. You get, $1,500. Tell her you'll give her the $1,000. Now you're better off $500. You just write her a check. You're still better off by writing her a check for $1,000. Now you both benefit in regards to it. There's many ways to do it, to have that conversation, to look at it and or to express to the court that they're being wasted, that maybe there's not enough income to even use it. They're just getting earned income credits. So I think there's ways to do it. You might want to look into basically how child support's calculated and the assumptions that the chart uses, because in Missouri, the chart makes the assumption that the custodial, and I use that loosely because you have 50-50, someone is typically designated as the recipient or custodial, which is her. So she would normally be entitled to the tax deductions here in Missouri, absent going what we call off chart. And so, again, a lot of what those questions are about in Minnesota require someone to really look at the judgment and give you some detail. Stephen, coming back, and was asking about the getting kicked out of the house or having her get sole possession. What does the judge look for? And I think I kind of talked a little bit about that, and that is, judge is looking for a couple of things. One, domestic violence. Can they continue to live in the same home? What's going on? It doesn't have to be physical. It can be emotional. It could just be that it's unreasonable. It's creating, emotional issues to live. The judge will look at alternative living arrangements, the ability to secure somewhere else. If you have another home, if you have family, it'll look to see if your wife can fund you to go to another place or she can go to another place. A number of factors, but typically, for example, in Missouri, they're looking for status quo. You want to maintain status quo, keep things as they are, pending further order. So, all right, continue. We have a few minutes left if you have any other questions, but let me wrap back to mediation. So mediation, I tell my clients it can go 8 minutes or 8 hours. It really is. I've literally in Atlanta, I walked in the door and walked right back out in under 10 minutes because their demand was so ridiculous and they wouldn't even budge. I'm like, okay, we're just going to go to trial. So I prepare my clients for that. Christopher, kind of in mediation in Arizona, how often are you doing it? Are you kind of in a formal way and informal way?
Scott, I always try to do some kind of a settlement informally in all of my cases. That's a conversation I have with clients right off the bat, is that the majority of these cases are probably going to settle and that we'll make efforts to do that. I do tell my clients, though, we're not going to beat our heads against a brick wall. Again, if you have an opposing party or opposing counsel that just is not willing to negotiate, then we won't waste time and money pursuing that. But I would say more often we do informal mediation than a formal mediation here in Arizona.
Yeah. Let me jump real quick, and we have I'm going to go 2 minutes longer since we started 2 minutes late. One of the other topics, we talked about domestic violence. I'm going to make real quickly one question before I get there, so we get to our questions. Oscar in California. Presley, Oscar has joint legal custody with the spouse. She has moved and has not informed me where she lives with the children. Again, I'm required to tell me where they are and the conditions of their residence. So kind of a relocation.
So in Florida, I would absolutely reach out to that spouse, see if they would give me that information of where they're living, an address. I know in Florida, you're required to keep your address updated and current with the court. So if that particular, I don't know if they have that requirement in California, but there would be an absolute way to figure that out. I'm dealing with that issue right now. In one of my cases, I don't know where the former spouse is relocated to, and we're currently trying to figure that out. And I'm probably going to have to file a motion here pretty shortly to go in front of a judge to get her to tell us.
So relocation, I'd be shocked if California doesn't have a significant restriction on relocation. I know Missouri, I will tell clients, the way that the statute's worded and included in your judgment, typically, you won't even be able to move next door. It talks about the custodial parent, or if you have equal time, that may trigger neither parent can move without notice. So first thing I would do, Oscar, is number one, if you have email communication, send an email that says kind of a demand. It's come to my attention you've moved. Number two, I don't know where you're living. Number three, you haven't provided me any notice or advance notice. Number four, I need to kind of know so I can proceed and know how far it is. Put them on notice so you can use this in court on any motion that you can use. For example, in Missouri, there's something called a family access motion. It's something you do in instances like this to get you to court faster. Oscar, you got to come in. I would tell you to do that. Real quickly, since we're almost out of time, Dave, with child going to college out of state now for a year, age 18, and original divorce in New York State. I now live in Nevada. X now makes 40% more income. Mine has not changed. Can either emancipation or modification be done? Let me quickly make a comment, then I'm going to go Presley and Christopher answer that as our last question. So there's something called Uniform Child Support enforcement. They're going to look to the state in which the decree was ordered, regardless of where you live when it comes to child support. So the law of the decreed state, which appears to be New York, will control. I have a case that went to the Supreme Court on this issue, where we argue the very thing. They were trying to emancipate a child, and we used Oklahoma as the decreed state, and they were trying to use another state to try to emancipate earlier. So you're going to look at your decree and look at the law in New York. We have offices in New York as well, and that will control. If it's 18, emancipate. If it's 21 or 22, take a look. Number one. Number two, when you look at college, certainly there's an argument in Missouri to modify and decrease child support if the child's living out of the home from either parent, and or you're paying and contributing towards college expenses. That matters. Typically what I see is courts saying, okay, I'm going to maybe lower it down to $100. If the child's going to return, it's $100 a month until the child returns in the summer, and then it goes back to normal. If the child doesn't return, then redirect the payments. Maybe you're paying your child support directly to the child. I've done that as well, to make sure that that pays for the expenses for the child while they're there. But I would look at emancipation. I would look at modification. Certainly if she's making a lot more, 40% is probably likely enough, but it's going to be done in New York State. Now, if she doesn't live there, you can file elsewhere, but the law will be using the state of the decree with regards to where the state issued it. So any other thoughts as we wrap up, Christopher or Presley?
Yeah, in Florida, it would be something very similar to that, Scott. With an income increase like that, I would certainly say seek modification. And in Florida as well, for child support, it only goes to the age of 18, whether the child or if the child is going to be graduating high school after they turn 18. But there's typically not an obligation in Florida past the age of 18 or high school graduation, unless they agree to do it voluntarily, which I do not advise my clients to do. I always tell them that if you want to give your child money, great, feel free to, but do not legally obligate yourself to do that.
Yep. Christopher, any thoughts?
Likewise, yeah. The only thought I would have is in Arizona, if the child is not actually residing with the parent, they are not entitled to collect child support. So that would most definitely qualify for at very least a modification. But here, if the child's already in college, they've graduated high school and they're over the age of 18, child support would be terminated.
Yeah, absolutely. And if you've been paying and the termination has hit, I think you certainly have the right to perhaps even seek a refund for overpayment of support, because the obligation to notify of emancipation rests with the custodial parent. So, all right, Presley, Christopher, thanks for joining and providing answers to many of the questions today. So appreciate it. All right, thanks for joining. Take a look for next month, doing the same thing. And we're going to do the same time. And you can chat with us. We'll give you answers to your questions. But in the meantime, check out our podcast, check out our YouTube channel filled with information, virtual town halls just like this. There are many before this where we were talking about for an hour on just specific topics, but I encourage you to subscribe to our podcast where we have an attorney from Cordell Cordell join me, and we just talk about issues, talk about topics like moving out, like domestic violence, like mediation, like child support and alimony. So I encourage you to do that. If you want a consultation, don't forget, you can go right now to CordellCordell.com. You can schedule online in any of our offices nationwide, including the United Kingdom, or pick up the phone, give us a call, nationwide, 866-DADS-LAW. Someone will be ready to take your call, get you scheduled with an attorney local to you, where you live, and we'll get you taken care of. You can do it Zoom, in person, or on the phone, whatever's convenient for you. So until next month, have a great week.